Good afternoon, everyone. Welcome to today's webinar. I have the pleasure of being here with Andrew Black. And today's webinar, we're going to be talking about jumping into the present, why amending docs are so important. We're going to give everyone just about a minute to get logged into the system, and we'll get started with the webinar. For those managers that are on the webinar today, it is a CU course. Please make sure that you do stay through the length of the webinar. Unfortunately, if you don't, the state does require it for you to be on for 60 minutes in order for you to receive your CU credits. We will be putting in the chat a link to fill out the survey that's required in order to obtain your credits. So make sure you wait till the end. You'll receive that survey, fill it out, and the team at Kane & Bender will go ahead and apply for those credits for all the camps. Again, welcome to today's webinar. We're looking forward to going over the topic of, the importance of amending your documents. We'll also be touching up on different items. So it looks like our numbers have pretty much stabilized here, Andrew. So why don't you go ahead and start off with an introduction of you and your firm?
You got it. Yes, my name is Andrew Black. I'm one of the partners at the firm. Want to thank every single one of you for taking the time out of your day to spend an hour or so with us. Affinity, I want to thank them as well for hosting this. Our firm, KBR, we're a full service community association firm. So the large majority of our clients are condominiums, HOAs, cooperatives, country clubs, any sort of property owners association all throughout South Florida. I am a board certified attorney by the Florida Bar. So this is what I do on a day in and a day out way. And yeah, just definitely looking forward to, I always joke, Raphael, this is sort of the board member homework course. Board members are volunteers. The pay is not very good, but hopefully I will give the board members out there some homework for them to review their governing documents.
Excellent. Thank you so much, Andrew. As for myself, my name is Raphael Aquino. I'm the co-founder and CEO of Affinity Management Services. We are an association management company. I come with an engineering background, so I'll give you an idea of our processes, how detailed we are and what we do. We're more of a boutique style operation. We do service the Tri-County area, Dade, Broward, and Palm Beach County. As you stated, Andrew, I'm excited to be here with you. I know every time we do a webinar together, we make it fun, we may crack some jokes, have a good time. But ultimately, we're here to provide some education for managers and board members alike. I do welcome both parties to feel free if you have any questions. We're going to be very loose with the webinar. So if you have any questions, please put them in the Q&A. We'll do our best to get to those questions and answer them today. If we don't, we'll get back to you after the fact. So with further ado, why don't we get started, Andrew, and start giving us some info on what's going on.
Let's jump in. Absolutely. I really like this course because it reminds me of a story. And for those of you who have heard me teach before, I probably sound like my father. I'm repeating some of my same stories and my same jokes. But I always start off by saying, when my wife and we were searching to buy our very first home, we were very excited. Maybe because I've been in this area of the law for so long, I thought, you know what? Maybe a condo isn't for me. Maybe I'll find a single family home, maybe with a small HOA. And we searched and we looked and we found one, which we thought was the perfect community for us. The governing documents were provided to us. I thought, well, if there's ever a time I have to, prove my worth to my wife, it's now. I better read these things line by line, make sure there's no funky language in them. I read them. Everything looked fine. I knew what the trash can rules were. I saw we paid our assessments per month. Everything was great. Closing was scheduled for, let's say, a Friday. Our real estate agent called me on, I believe it was like a Thursday morning. And I'm thinking, that's strange. She's really dealt with my wife primarily through this whole process. Why is she calling me? There must be something wrong, right? So I answered the phone. She says, Andrew, I'm so sorry, but the HOA, the property manager just called me and said, the board needs to screen and approve you and your wife before the sale can go through. And I thought, that's interesting. I read the documents. There was no sale approval authority there. And I thought to myself, how do I approach this? I don't want to come from big bad attorney standpoint. We want to be owners there and, love our community and get started on the right foot. So I decided to, write the manager a very nice email saying how much we were looking forward to being new owners. I understand that you are requiring my wife and I to be approved. However, I reviewed the governing documents. There's no sale approval authority at all. So I'm happy to give my information. You can run a background on me if you want, but we have closing scheduled for Friday. So unfortunately, if it gets held up based on the association attempting to exercise rights it does not have in the governing documents, there could be a potential problem. I don't know if I even used that word. The manager within the hour, much to his credit, called me back and said, Andrew, you're the first buyer in 10 years that's ever essentially called the association out on something like that. And I always
or read the documents.
or read the documents, probably, right? And I always share that story because what I really want you all to take away from today is there's always these fairy tales out there that our documents somewhere say this. Somewhere we don't allow dogs, or somewhere we don't allow commercial trucks, or somewhere every buyer needs to be approved. So I like to start off with that story because the main thing, and I like to kind of segue into the sale and lease approval process, because that's a very common question we get a bunch, especially with the market, how it's been. There's been lots of real estate transactions. And whether you're a condominium association governed under Chapter 718 of the Florida statutes, that's the Condominium Act. I'm sure you all know that. Whether you're a cooperative association governed under Chapter 719 of the Florida statutes, or whether you're a homeowners association governed under Chapter 720 of the Florida statutes, none of those statutes give boards the authority to screen or review and approve someone who wants to buy, someone who wants to rent, someone who wants to occupy. Sometimes someone's just there residing. There's no lease, there's no sale. So I joke that board members have some homework, and your homework is, if you think you have the ability to review either a buyer, a tenant, someone who wants to move in, you have to make sure that your declaration, that's the key document, not just a board-made rule. The declaration of condominium, if you're a condominium association, if you're an HOA, it could be called lots of things. It could be the declaration of covenants and restrictions. If you're a co-op, if we have any co-op people out there, there's a proprietary lease, the bylaws, co-ops kind of have their own unique set, but the declaration must clearly have what your approval rights are. And sometimes it'll have sale approval rights, but there's no lease approval rights. Or alternatively, it'll have lease approval rights or not sale approval rights. Mm-hmm. Another twist on that is sometimes property is transferred via just what's called a quitclaim deed. It's not a sales transaction. There's no money being exchanged. Let's say my best friend from college hit the Powerball. He came into lots of money. He says, Andrew's been an awesome friend. I'm going to give him a present. I'm going to gift him this home. And he might just transfer it to me via a quitclaim deed. So that's just a transfer of title. That's not a sale. So the key takeaway is, does your declaration have clear sale, lease, transfer, approval authority? And I think that's an important topic to highlight on.
Yeah, and if I can add to that as well, Andrew, because so those are definitely great points, is I can tell you that when we've taken on certain associations and we're going through that review process, our recommendation is always, hey, have the attorney review this, provide an opinion on several things. So in that way, we're clear on the way it should start the relationship. Because as you stated, many times it's, oh, well, this is the way we've done it. And a perfect example to that is where we've seen associations requesting a certain credit score, which is okay. But if your documents have to permit that, what is it outlined? What's the score that's permitted? Is there a range? Whatever it may be, because last thing you want to do is, find yourself in a situation when you're denying someone for a particular credit score, and you could be technically discriminating in one way or another, and not having the proper backing, and find yourself in a very difficult situation. So I wanted to add to that because I know that we personally have experienced that challenge with certain associations wanting to restrict that and not having the abilities not being in the documents, I guess I should say.
Exactly. No, that's an excellent point. And that goes into, just because you have the approval authority, in our view, you want to outline those what's called good cause factors to possibly reject someone. Because if you think about it, turning someone down, whether it's to buy or to rent, that's a pretty serious power that boards are using. I mean, the United States, essentially, the concept of property ownership was one of the founding, things, right? So if you're someone, they can't sell property that they own. You want to make sure you're on solid footing. And it's really important because a lot of times people will claim they will sue, but they can't prove what the damage is, right?
Yeah, correct.
And really to have a successful lawsuit, there needs to be damage. And with a sale, you can actually prove damages, which is a key cog of that claim. Because if the board overstepped its authority and turned down a buyer where maybe they didn't have sale approval rights, or maybe they didn't have well articulated good cause factors, and you rejected a buyer, and the owner, the selling owner, has to relist his or her home. They find a buyer, a new buyer, and let's say that new offer is $20,000 less than what the old offer was. Now, you might be thinking, in this market, that won't happen, perhaps, but you never know what's going to happen 5 years from now, right?
Correct.
So if that new buyer comes in at $20,000 less, that selling owner then has documented financial damages.
Correct.
And it's, certainly a very important thing that boards want to avoid. So I always like to start off with that sale lease approval process. And we talked a little bit about the declaration is the key document. And if you don't have, for instance, good sale lease approval authority, and you want to amend the declaration to include that, I think it's a good idea to go through what the actual amendment process is. What options are there? And number one, and again, this is that board member homework, maybe on Thanksgiving on Friday when you're all stuffed and your family's bothering you, you pull out your documents and you highlight things that maybe you're not sure are there or not. But what's the actual amendment process? I can't think of a set of governing documents that I've seen where the governing documents don't have an amendment provision there that will outline you need this number of owners to vote in favor. It's almost always, if you're looking, for instance, to amend your declaration to add sale lease approval authority, almost always your declaration will have that amendment provision there. It could be a wide variety of things. It could be 2/3 of all owners. It could be 75% of all owners. It could be a majority of all owners. And sometimes I get asked, what does that really mean? It means 50% plus one. Okay. So if you have 20 total units or 20 total homes and you need a majority to approve something, it's 50% plus one. Attorneys hate math, but it's 11, right? 10 plus one. Make it real simple. So that's a majority of all owners. That's the easy way. Sometimes we'll see the amendment provision will read something along the lines of, you need a majority of the owners who vote in favor of it that are in attendance at the meeting.
Correct.
I like to think of that as a majority of the quorum,
Correct.
not a majority of all owners. And I'll use my simple math equation. Let's say you're a condominium. Your quorum's just a fancy word. It's just the minimum number of owners that must be at the meeting, either in person or by proxy, for the meeting to even to happen. No quorum, the meeting can't happen. So for condominiums, almost always, your documents will say that a quorum is a majority of all owners. And then if your amendment provision says to approve an amendment, it's a majority of the quorum, we wouldn't know what that number is until you confirm what the quorum number is, right?
Correct.
So if you have 20 total homes, if your quorum's a majority, that's 11, right? Then it depends how many owners show up. Let's say 12 owners show up. You would have reached quorum, right? You have more than a majority are there. Then it would be a majority of that 12. You would need 7 to approve that amendment. Using that fact pattern, if 14 owners showed up, you would have reached quorum. You would need a majority of that 14 to vote in favor. So this might seem like a simple concept, but I can share with you, I've seen lots of fact patterns where the actual amendment requirements aren't understood, and where some boards think they only might need a majority of the quorum, but they really need a majority of everyone, or the opposite. They think they need a majority of everyone, they only need a majority of the quorum. So it's just important to be aware of that.
Yeah, and if I can add to that as well, Andrew, I mean, also keep in mind that, and correct me if I'm wrong, you know, there are changes to the quorum requirement also if you've suspended owners' rights. So those are things that as board members you have to keep in mind, and that's why, again, not because it's just Andrew on the call, you definitely need to be working with your attorney with this entire process. I mean, it's not just the meeting itself; it's the language, how the language is written, how it's presented, how things are removed with cross outs and so forth. So it's very important that you don't pass this responsibility to your CAM, because technically he would be outside of what his licensure permits.
Yes.
So if you're a CAM, make sure that if your board is considering these kinds of changes, that you're having the conversations with your attorney, and also you're looking at all the little potential ways that if you need to reduce that number, or it's too large of an association, that you could suspend voting rights, go through that process through a meeting. That's going to change your quorum requirements, and that may allow you to make whatever changes may be necessary. So these are things you should be keeping in mind. I do have a question here from Rick that I want to throw at you now, because it was about something right before. And Rick asked, it's basically along the lines where you were talking about, can an HOA prohibit an owner from selling their home to a company?
That's a great question. And the answer is if your declaration prohibits what I call entity ownership or non-natural person ownership, whether it's a corporation, a limited liability company, and LLC, if your declaration, and we've seen lots of communities that have it, and we've actually drafted amendments to prohibit entity ownership. If your declaration says it, then yes, in our view, that would be an enforceable restriction. And in that case, if an owner did want to sell to someone, to some corporation that is prohibited, the board could turn that person down. And the reasoning behind that is some boards feel, and I think it's a legitimate thought, is that if you're concerned with the number of investor owners or the number of rentals that your community might have, one tool is to prohibit that type of entity ownership, and that may assist in, speculative buyers, essentially.
Okay, excellent. And then back to what we were talking about, Kate asked, does suspending rights change quorum or just the number of voting?
Yeah, so it actually, it does both. So let's say you have 20 homes and you properly suspend voting rights because someone's 90 days past due. The board has a meeting, it's duly noticed 48 hours in advance. You suspend those, delinquent owners. You have to send notice to those delinquent owners, notifying them that their voting rights have been suspended and they'll be reinstated once they're paid in full. Let's say you suspend, 2 owners, okay? You reduce the 20 homes to 18 total homes.
Right.
So you think of your community now as having 18 homes. So quorum, using the example, if quorum is a majority, it would be a majority of the 18.
Correct. Excellent. Yep. That's why, as I was stating earlier, again, you have to look at these things, and the same thing applies for, we're kind of in budget. Well, hopefully you already have your budgets approved, but same thing would go as well with your quorum requirements for reserves clarification and all of that.
Yep. Great. All right. So that's a very important part. So your homework so far, for those of you who are taking notes at home, is if you do the sale lease approval process, make sure your declaration spells that out, that the underlying authority is there. That's homework assignment 1. Homework assignment 2 is you should know, if you're a member of your board, you should know what the actual amendment requirements are. What percentage, what number of owners do you need? What is the quorum? What's the quorum amount? Okay, so that's homework assignment 2. And Raphael brought up a great point. Let's say your amendment percentage, and I've seen it be as high as 80% of all owners or 75% of all owners. That can be a very high number to reach, just because sometimes there's owner apathy out there, right? It's hard to get owners involved unless you're going to special assess them or something, right? It's hard to get them engaged. So if you do have a high amendment approval requirement and you have a lot of good ideas to bring your documents up to date, some of these documents were drafted 30 years ago, 40 years ago plus. So if you have some amendments you want to go through, sometimes a good idea is to propose an initial amendment, a standalone amendment, to reduce, for instance, that 75% approval requirement to something more reasonable that you can get. Maybe you reduce it 75% to maybe 2/3 majority, maybe 2/3 of the quorum or a majority of the quorum. And those can be effective tools to make sure the amendment process can actually get done. So those are your 2 homework assignments so far. I want to just touch base on a couple other areas of possible amendments boards want to think about. One of them, really, it's for both condos and HOAs, but I'll start with the condominium side of things first, which is the material alteration process. I'm sure you all have heard that phrase. A material alteration basically means some perceptible change in the use or appearance, if you're a condo, of the common element property. It's some aesthetic change. The Division of Florida Condominiums, which is the state agency that governs condos, they have a fairly conservative view of what constitutes a material alteration. And in some of their published arbitration decisions, they've even said, a change of the color of the paint, that's a material alteration. We've seen where even certain landscape changes could possibly be a material alteration. So in a condominium setting, and we're not talking about necessary maintenance projects, right? If something's broke, the board always has the authority to fix that. But if it's a material alteration, some capital improvement, some aesthetic change, if you're in a condo, the way the statute works under 718 says, check the declaration first. What does the declaration say? And if the declaration is silent, you need 75% approval of all the owners. Now, oftentimes, not always, but oftentimes, your condo declaration will not be silent. And the approval rights could be a wide variety of things. It could match the statute. It could say 75% of all owners. It could be 2/3, a majority. We've even seen oftentimes where it even gives the board the authority without a vote of the owners to undertake a material alteration if the cost of the alteration doesn't exceed a certain dollar amount, $10,000, $20,000, $50,000. If it's under that, it gives the board the authority. If it's in excess of that, then it'll say what the owner approval requirement is. So I hear a lot of these misconceptions out there from condo boards. They always assume that it's 75% approval, or they always assume they need owner approval, when in fact, your declaration, you have to follow it. So your homework assignment number 3 is, if you're thinking about these capital improvement projects, what's the actual approval process we need? For HOAs governed under Chapter 720, interestingly enough, 720 is silent. It doesn't have the same type of language that 718 has. So if you're a homeowners association governed under Chapter 720 and you're thinking about these type of capital improvement, these material alteration projects, you want to check your documents. What do your documents say regarding the authority of the board to do that? And you need to follow that. If your documents are silent, there's actually language in what's called Chapter 617 of the Florida statutes. That's the Not-for-Profit Corporation Act, which HOAs are a not-for-profit corporation. And there's language in that Not-for-Profit Corporation Act. Again, it's Chapter 617 that actually does give not-for-profit corporations via the board the authority to do improvement projects. So that's an important topic. I want to make sure we didn't leave here today without boards being aware of that.
Excellent. While you're there, I want to go ahead and touch upon this question. I don't know if it's too early, but Rick asked another good question. He asked, basically, are architectural guidelines a part of the governing documents? And most of those guidelines, are they recorded with the court? Do amendments to those guidelines or association, call them resolutions? And do those need to be recorded with the court?
Gotcha. So he asked a lot of good questions, and I'm going to touch base on all of them. I think now is a good point. Usually I do my little attorney spiel at the start, so I'm a little remiss that I did not do this, but I would want to make sure I'm very clear. Obviously, today is general information, right? It shouldn't be construed as direct legal advice for your particular fact pattern. A lot of these issues are what I call document specific, meaning every community, its governing documents are unique. So correct. I wouldn't know what's in them unless I reviewed them. So a lot of these questions need to be reviewed by whoever your association attorney is. Getting to Rick's questions, the declaration needs to have some underlying authority for the association to approve architectural changes. Okay, so there needs to be something in the declaration that gives the underlying authority. Okay, in my view, your declaration does not need to specify every possible architectural spec that will be allowed. It doesn't need to say we'll only allow, gray tinted shutters, right? It doesn't need to get to that level of specifics. But if you have the underlying authority already, the board does need to adopt. And usually the documents will allow the board to adopt these types of architectural specs. The board does need to adopt what types of architectural improvements will be allowed. And that gives the owners, it makes just for transparency. If I'm an owner and I want to install a fence, well, I should know what type of material will be approved, what height will be allowed, all of those things. And that usually the documents will give the board the authority to adopt those types of specs. They don't need to necessarily be recorded with the county, okay? If you have previously recorded the architectural specs and you want to modify them, we suggest obviously recording those changes. That way the public records has the most up-to-date version.
Yep.
But if you never recorded them, in my view, there's not a strict legal requirement that you must record them. certainly once they're properly adopted by the board and your association council can walk you through that process, you're going to want to publish them to the owners, so the owners know exactly what those changes are.
Excellent.
And in fact, just to sort of add a note, if you're an HOA governed under 720, there's language in 720 that even says you need these types of published guidelines if you're going to review architectural changes. It's most often in HOAs, but certainly condos, there's an authorization process too, you know?
Yeah, and it's to be honest, from a management perspective, it's always great. We always recommend it. It's always much easier to manage the process because you avoid assuming, you know, okay, you know, French windows, solid pane windows. That's sometimes simple, but in certain instances, it's not that simple. So the more guidelines you have, the easier it is for your committee, the easier it is for the community, and the more transparent it is for all.
Yes, we love attorneys love, obviously, we like processes, right?
Yeah.
And it just makes everyone's life easier, and that way you know, avoid claims of selective enforcement or
Right.
you know, waive. There could be a whole host of things. So that was a good, very good question, Rick. I'll do a couple other sort of homework assignments, and then we'll kind of see what type of questions that we have. Going on the sort of the material alteration section, because it does come up, especially with capital improvement projects, is sometimes boards are thinking about, you know, a large project, whether it's concrete restoration, it could be a new clubhouse, whatever. And they don't have operating funds available, and they want to get a loan, right? You know, or a line of credit. And banks typically think associations make pretty good customers, right? Because banks, the security for their loan is the assessments that the owners pay, right? So associations are usually a pretty safe credit risk from that standpoint. And one of the things banks will almost always ask is that the association needs to obtain an opinion letter from their attorney confirming that the board has the authority to enter into this loan, to borrow these funds, to get this line of credit. So if you're thinking about that, one of the first things to check is, do our documents, whether it's your declaration, whether it's the bylaws, right? The bylaws are another set of governing documents that deal with corporate matters, whether it's your articles of incorporation, whether those documents require an owner vote to approve a loan, okay? Because if they do, you need to follow that. And I've had the unfortunate role, and I always say don't shoot the messenger, but I've had to share bad news with either a manager or a board who thinks they're all rocking and rolling, ready to go forward. And I tell them, look, we're putting our name on our letterhead, attesting to the fact that this board has done everything that it's required to do. So if you need an owner vote, it has to be done. It's not an optional thing. If your documents require it, you need to get that owner vote. So that's something you need to be made aware of. So that's only homework if you're thinking about going through the loan process. And one thing I just want to touch base on, going back to the actual amendment process itself, we talked about verifying what the actual amendment process is. A lot of times there's a meeting of the owners where that amendment is presented. It's a meeting of the owners because obviously the owners are voting on it, okay? There might be a way for that, there might be an alternative way that your board might want to consider to present the amendment to the owners to vote on. For HOAs, you already have this authority. This is called the written consent process in lieu of having a meeting. So the written consent process is you basically send out a form. It's basically just a ballot that an owner will sign and date, and the owner will sign off saying he or she agrees to the amendment change. You always need to send the actual amendment to the owner so they can see the actual amendment language with any changes being underlined, any language that's being removed, being stricken through. So you send out the actual amendment, you can send out that written consent form, and the owner can just sign off on it. They can turn that consent form back in, and that written consent process, with that, you don't need a meeting of the owners. You don't need to send notice of a meeting. You don't need to get quorum. Don't need to even see owners at all. Sometimes boards prefer a meeting because owners can attend and ask questions. But if it's a pretty innocuous change or it's something that the board knows the community supports, that written consent process is something you want to think about. If you're a condominium, in our opinion, in order to use the written consent process in lieu of having a meeting, your governing documents need to provide that authority. A lot of them do, but if you're not sure, get with your association counsel. That written consent process, let's say your amendment provision says you need a majority of all of the owners to approve it. With that written consent process, you have 90 days from the date that first consent form is turned in to get a majority of them in, okay? So just be aware of that. I always like to point that out, just the actual process. You do have that written consent process available to you all. Obviously, just to complete the amendment process, if you do get the required number of owner votes, whether at a membership meeting, and again, owners can vote by proxy at a meeting if they're not physically there, and the proxies for that meeting, they're also valid for 90 days. So if you don't get enough votes at the meeting, you can recess that meeting to a date. Don't go more than 90 days out. You have some more time to get proxies. But if the amendment is approved either at a meeting or via the written consent process, once it's approved, the process isn't over yet. You need to record the amendment in the county, in the county public records. You have a certificate of amendment that's signed off on, and it records that change. And that amendment is effective from the date of recording going forward. So that's obviously an important thing. And you want to certainly keep all voting materials that you all have. It's interesting for both condos and HOAs, you only need to keep voting materials for 1 year.
Yeah.
Doesn't mean you can't keep it longer, but if for some reason you don't have the voting materials that happened 2 years ago, 3 years ago, and an owner says you must have that, you can calmly say, actually, the statute only requires us to keep it for 1 year.
Yeah. What you do want to do is just make sure you're keeping the minutes, because the minutes are going to fall under a separate statute.
Forever.
Yeah.
Yeah. Forever.
Yeah.
There was a change not too long ago.
Correct.
The minutes must be kept forever. So in the
Yeah.
year 2094, there should be minutes of the meeting from 2021, there.
And Stephanie, I want to answer this question. She asked, what's the best advice to amend if the association can never achieve the required votes? So that's a challenge with many associations, especially the ones that have the higher percentages of 75% of all the owners. What I recommend, and especially nowadays, is either an online voting platform. There are online voting platforms that can assist you with your amendment process. There's a way to get individuals to log on to the platform, because sometimes that's a challenge. So one of the recommendations that has worked is either do a survey. That's very important to residents. So it could be a survey. If you don't have reserves, we're considering reserves. Would you be interested in it? And all of a sudden, everyone's going to sign up to the platform just to do the survey. And then you could have them all signed up and ready to be able to vote for any particular amendments. But where we have found success is when there's a lot of communication, there's multiple avenues available for the residents to be able to vote, whether it be paper or online. That's where we're able to see that you're able to hit the numbers that are necessary.
Yeah, that's an excellent point. Certainly electronic voting, the statute does allow that. Before it gets up and running, the board does need to meet and just agree to do that. Correct. And then you got to get that owner consent, but it's a great idea. Send a survey out to get the ball rolling, and then you can then work that into getting the owner's consent to do that. And also, I think it's a great idea. I mean, seems common sense, but I don't see boards always do this. And if you're self-managing, you don't have a professional management company to kind of guide you through this, you want to explain to owners why the amendments are being presented. Why is the board even doing this? Why does the board think this is a good idea? There is what I call a sales process, right? And you want to be honest and straightforward. We think this change will be the best interest for the entire community because of the following reasons. We need a certain percentage of owners to vote in favor. Reasonable people can disagree. People can vote no. There is no harm in that. That's why you have that amendment process. So it should never be an adversarial thing. It should be, this is why we're recommending it. These are the language that our attorney has assisted us in drafting, and this is why we think it should go through. And the more communication, the more transparency, then the owners can make an informed choice, and they see why these things are being presented to them. If you're dealing with just non-responsiveness, obviously electronic voting is out there. You can also appoint an amendment committee, have 2 or 3 or 4 people, find your most charming owners you have out there and have them speak to 3 of their friends and kind of explain what's happening. If you have an on-site office, if you're using the written consent process, have the consent forms right there. If you have a meeting coming up and you want to use a proxy, have them right there. Make it easy for owners to be engaged. At the end of the day, it does take work. And that's why it's good. You have 90 days. The proxies for a meeting are valid for 90 days. And if you use the written consent process, you have 90 days as well from the date you get that first consent form in. All right. So we have a few more minutes. I want to just touch base on a couple other sort of homework things I think is a good idea. One of them can't get too in depth. It's sort of outside the scope of, here, but I think it's a good idea just to be aware of this. And is do your governing documents have what's called Kaufman language? You all may have heard that phrase. Kaufman language simply means it's the phrase as amended from time to time. What Kaufman language deals with is, you all know that the Florida statutes, the legislature in Tallahassee every year, they make changes. And we have attorneys in our firm that are very involved in the legislative process to come up with some common sense changes that will help us all. And the statutes change each year. And if you think about it, your declaration is a contract, right? It's a binding, enforceable contract. It binds you as the current owner of your property, and it binds future owners. And so the statutes change every year. So the famous question that attorneys battle over is, do all of the new changes to the statute, do they automatically apply to our existing governing documents? And the answer isn't always yes. And there's an analysis that needs to be done, and it's outside the scope of here. But one way you can ensure that substantive changes to the Florida statutes will automatically apply to your existing governing documents is if your existing governing documents say something along the lines of this. This declaration of condominium is subject to Chapter 718 of the Florida statutes as it's amended from time to time. That Kaufman language then sweeps in any substantive changes to the Florida statutes. So that's just homework. It's just homework over Thanksgiving, over the holidays. Check to see if your documents have that. If they don't, and you want to know more about whether that may be a good idea for your community, and you might be doing other amendments. I'm not suggesting you need to do a Kaufman amendment as a standalone. But if you're doing other amendments, that might be one you might want to think about but I certainly suggest getting with your association counsel just to chat about that Kaufman language and possibly adding that in. One other item I wanted to chat about, and let me get right here. Okay, yes. Dealing with what I call fees, whether it's charging, let's say, a transfer fee if you have sale or lease approval, or charging a security deposit if you have lease approval rights. Those types of fees, your documents need to provide that authority for it, okay? In a condo, the statute talks about it can be $150, but it also says you can only charge that if your documents say so. And if your documents say so, that's what the maximum fee is. For HOAs, 720 silent, but you need to make sure that that your documents in an HOA have that transfer fee authority. The security deposit for a tenant, it's the same thing. Your documents need to provide that security deposit authority. If they do, the maximum amount is 1 month's rent. And remember, because I get a lot of questions about security deposits, they are refundable, right? And they're only to protect against damages that the tenant may cause. They're not to be used for, let's say you adopt a fine because the tenant violated a rule. That's not what the security deposit is for. If the owner stops paying you his or her assessments on time, that's not what the security deposit is for. It's refundable. It's only for damages. And if the tenant causes damages, there's a process where you need to actually send a notice, and there's a statutory form out there where you're making a claim upon that security deposit, and you have to outline what the why that claim is being made, and the tenant actually has the opportunity to object to it. So just keep that in mind when we're talking about the security deposit.
So I do want to stay there because there's an anonymous question that's right in front of me, has to do with security deposits. So this is an example that they're giving. They're saying it's an HOA board. They have a declaration compliant lease deposit of X dollars. It was done via resolution, and now they wish to increase it to a larger amount with a new resolution. They're asking, must the board provide the owners with 14-day notice of its planned consideration of the said resolution, or can it be put into an agenda 48 hours in advance?
That's a great question. My first answer is check what your documents say regarding the underlying authority, right? What I'll say generally about board-made rules, whether it's a board resolution, which is just essentially the way the board is just setting forth whatever action they want to take. If the rule is regarding the use of the individual homes, or it's regarding the use of the individual units, both 718 and 720 require the board meeting to be noticed 14 days prior, actually mailed and posted 14 days prior. Some declarations might allow the board to just modify the security deposit scheme, and just changing the dollar amount. There perhaps is an argument that's really not regarding the use of the unit, right? It's just changing what the dollar amount is. So, I think that's primarily a document specific thing that I would get with your association's counsel just to confirm, how much notice needs to be given, and if in fact the board even has the authority to even make that change. I always say if it's in the gray area regarding use of the individual unit or the use of the individual homes, maybe I'm conservative, but I would prefer just to take that extra step, right? That avoids any challenge. Just mail it out 14 days prior. Okay. All right. So I think I just want to also summarize the hierarchy of what the governing documents are. We've talked about all of them, but I just want to reiterate that. Okay. The declaration is document 1. That's the constitution of how your community operates. Okay. Then underneath that, You have the articles of incorporation. That's more of the corporate structure. You have the bylaws after that. So it's declaration, articles, the bylaws. Those three, okay, those are the governing documents that I would say virtually every community has. And when you buy a unit or a home, you get that. The fourth one is any rules and regulations that community has. Oftentimes they're board-made rules. And of course, a board-made rule cannot conflict with the other three. So if your declaration says, dogs are allowed up to 20 pounds, and the board says we're tired of dogs, we're going to adopt a rule that says no dogs allowed, that board-made rule would conflict with what your declaration says, and there would certainly be a basis to challenge that rule. So I think it's a good idea to know what your governing documents consist of, be aware of what's in them. If you're a board member, we all know you're required to be certified, right? It's either taking a state-approved education course or signing what I call that Scouts Honor Statement, right? That you have read your governing documents, you agree to uphold them. So I think it's a good idea to know what's in them. If you're in a condominium, you're actually required to have what's called a frequently asked question sheet. Hopefully you managers, especially, and members of the board of the condo should certainly know that, where someone wants to buy, it's part of the official records, where it's a frequently asked question sheet where it confirms what's the assessment amount. It confirms what lease restrictions there are. It confirms whether you're part of a master community. It confirms what other sort of use restrictions there are. So certainly if you're a condominium and you don't have that frequently asked question sheet on file, you're going to want to get one completed. The form itself, the Division of Florida Condominiums has the form with the questions there, but you obviously need to get your attorney to review what your governing documents say, so you have accurate information added in. Management provides what the assessment amounts are. If you're self-managed, obviously the board provides what those assessment amounts are. Okay, I'm gonna take a look at.
You want to get into the questions? Sure.
Yeah.
So I have Anne has asked twice, so I kind of want to touch up on her. She asked,
Sure.
I know this one's going to be tough, but either way, if your legal recorded documents are from 1960s, what is the estimated cost of having your attorney review and make the recommendations of revising the documents?
That's a great question, and I know they want to hear exactly how it costs, right? It really depends, and I know attorneys give that answer, but here it's really true. It depends how extensive your documents are. Have there been any amendments since that time? We've seen some documents that are 40 years old and there's been 20 amendments to it. So it's going to take obviously more time to coordinate and making sure that your attorney has a good idea. I think if you're looking at doing a complete document rewrite project, when it comes time to adopt your annual budget for that year, you want to get with your attorney and include it as a line item for that year, because it's not an inexpensive process. And any attorney who tells you that probably just wants the gig, and then you might have sticker shock when the whole process is done. It's obviously a lot less expensive if the board already knows you have 1, 2, or 3 items you already want to change. But an entire document rewrite process, that could take 10 hours. It could take 20 hours. It could take 30 hours, depending on how much that is. We certainly work with our clients. We oftentimes will even be willing to flat rate it. That way the board knows it's a not to exceed this amount, so they can plan accordingly. And it oftentimes only works out to a fairly insignificant dollar amount per home to get a brand new up to date set of governing documents. So I did my very best to give you some flavor. I'm certainly not going to commit to a specific dollar amount.
No, and it's good that you mentioned that about about putting it in the budget. I think that's a great way of handling it. It's a project that's not overnight because again, as you start to peel back the onion and you're attorney and you're going back and forth with management, you're going to realize, okay, well, maybe we should change this. Also, you have to keep in mind the strategy of how you're going to present it, because if you have an association that are going to agree to certain terms and not to other ones, you may need to break down the voting process to either per amendment or groups of amendments put together, no different than what our kind of government does, so that you can get through what's necessary for your community. Last thing you want is to have 40 amendments put in all this time and you're only taking one vote for all 40. So these are different strategies that you have to keep in mind when you're going to go through that particular process. I have a question here from Jay Kevin, and Jay Kevin asks, what are the consequences of not following the law or declaration when changing the color of a building without the owner's approval? With no meeting was held, only a survey asking owners which colors they like.
Gotcha. Well, there's no condo jail, so that's not an option. But certainly, if your documents require an owner vote and an owner vote was not obtained, because again, it's document specific, and you're in a condominium, certainly a complaint can be filed with the Division of Florida Condominiums, indicating that the board undertook that alteration without the proper authority. And in theory, if the vote is not taken, in theory, the state could make you paint it back, right? Yep. So, you want to, obviously, if you're on board, that's the worst case and you want to avoid that. So that's why it's good to prep and plan prior.
Yeah, 100%. And if I recall correctly, there was some laws, I think, changed about a year or 2 years ago, because there was people before painting and then taking the vote after the fact. And I think that had changed. So whenever you're making any of these material alterations,
do it first.
Yeah. Make sure you're getting your votes first, because you don't want to find yourself in a legal battle having to do things twice. I have a question here from Sharon, and Sharon asked, does the written consent that you were discussing earlier have to be in the HOA docs?
If in our view, if you're an HOA, no, there's language in 617, which is the Not-for-Profit Corporation Act, that would authorize the written consent process. For condos, in my view, the documents do need to authorize written consent. I'm aware there's legal practitioners out there that in their view, condos can do it, whether the documents say it or not. I don't share that view. I'm not aware of any case law that's on point. So if I'm advising a condo client, I err on the side of caution and say the documents need to say it. If you're an HOA under 720, my view is your documents can be silent. You have the authority based on 617.
Okay, thank you. China asks here, besides the minutes that are required to be kept forever, what other documents are needs to be kept forever?
Just your governing documents. So the declaration, articles, bylaws, and the rules, that makes sense, right? You got to keep those permanently. Any amendments there too, those have to be kept permanently. But yeah, all of the other records, for the most part, there's a couple exceptions. I mentioned voting materials are 1 year. But 7 years for other stuff, that's the rule of thumb you want to follow, is 7 years for other official records.
Excellent. Karen asks here, what's the difference between rewrite and reinstatement of documents? Which that's a good question. I think she may be referring maybe to MRTA with the reinstatement.
Yeah, I'm not exactly sure. A document rewrite is just an amendment process. You're changing what's there, okay? If you're an HOA, okay, there's a Florida statute. It's called the Marketable Record Title Act, which says every 30 years you need to the board needs to take action to preserve the HOA governing documents. And if the 30 years expires, there's a process to reinstate or revive those HOA governing documents. The preservation process, every 30 years, it's a little procedural heavy, but it's not too bad. It's a
Yeah.
board vote. If the 30 years has expired, the revitalization process to get them reinstated is a much more involved process. So you want to avoid that. So if you're an HOA and your documents or your community has certainly been around more than 30 years, you want to confirm with your association counsel. Maybe we'll add that to the homework list.
Yeah.
That marketable record title act process has been done.
Correct. Excellent. Yeah. And it's very important to keep that date in mind, because if you do let it pass, you can still reinstate it. It's a process, but technically owners can argue that they don't have to pay maintenance fees anymore.
It becomes a big headache.
Process. Yeah. Matthew asked here, if the original vote to amend the documents is going to fail at the HOA meeting, can the board adjourn the meeting without taking a vote and try again in 90 days?
Yeah, so again, the proxies are valid for 90 days. So if the board wants more time, okay, there can be a process to recess and reconvene that meeting to a future date. Just make sure it's not more than 90 days past due. Technically, the approval to recess and reconvene, since it's a membership meeting, it's the owners that are there can vote in favor of that. So yes, there is the possibility that that meeting could be essentially extended and reconvened to a later date. I've seen it even happen where they recess and reconvene it for 30 days. They don't get enough, and then they do it another 30 days. So you can recess and reconvene more than once, as long as the total number of days, 90 is the furthest out date.
Excellent. And just to switch gears just a bit, for those CAMs, I'm putting the survey link up. If you haven't received it already, please make sure to, it'll be in the Q&A. Please make sure to fill out the link so that you can receive your necessary CU credits. Just fill out that link and it'll request all the information that's necessary for Jeffrey at KBR to give you the credits that are necessary for the course. Let me see what other question I have here. I have from an anonymous. It says, our county requires homeowners having alarm systems, pets, and home-based businesses to register with the county. If our declaration is silent on this point, can our HOA board lawfully adopt a rule requiring homeowners to submit copies of their county registrations to our management company?
That's a very good question. The scope of the board's rulemaking authority is document specific. So you got to get with your attorney on that. You know, usually there's language actually in the documents I've seen a lot where it requires owners to abide by all governmental regulations. So I'm not convinced that you might not already have certain language in there. I think the board needs to ask itself, do we want to be involved in that sort of administrative housekeeping process? To me, if it's a county requirement, why not have the county enforce it? You know, my initial thought, it'll save a lot of heartache and time. Your manager will probably thank you as well.
That's why I'm nodding my head saying like this.
Yeah.
There's so many changes that occur at a local level that it would be too much for the board as well as management to manage that. So if there's certain responsibilities that fall on the county, I would definitely recommend to just keep it that way, unless there's something very specific to your community. You know, I would definitely agree with Andrew there. I have a question here from Ram. He says, regarding material alterations, can changes be made, this for an HOA, can changes be made for like new trees, installation of doggy bag stations, cycling maintenance bars, trigger, and material alteration? So I guess what my understanding is, can an HOA board install trees, doggy bag stations without having to take a material alteration vote?
As long as, so for HOAs, you follow what your documents say. If your documents are silent, in my view, yes, the board would have the authority, because there's language in 617 that gives not-for-profit corporations the ability to improve property, you know. So check your documents if you're an HOA. If they're silent, in my opinion, the board likely would have the authority.
Okay, excellent. We'll do two more questions just to be respectful of everyone's time. John asked, with regards to MRTA, it's renewed every 30 years and then every 10 years after that? It's the question.
Well, it's really an every 30-year process. Some declarations have funky lines. Some HOA declarations have some funky language that references like a 30 and then a 10. You might be thinking of the 40-year building recertification, which is every 40 years, and then it's recertified 10 years after that. But for the MARTA process, you just need to be worried about that 30-year.
Okay. And I have here a little technical one. It says our HOAs had rules put in the covenants that all pickup trucks had to be garaged and no vehicles can be parked overnight on the streets. At the time, the HOA owned the streets. Now the streets are owned by the county. Can we enforce the rules that vehicles have time limits for parking on the streets?
I'm going to punt a little bit on that one. That's a very good question. I would be curious when the ownership transferred from the association to the town. I would confirm with the town code, see if there perhaps is a code restriction that they would be willing to enforce. And if the transfer of ownership occurred, did the governing documents, were they amended to reflect that as well? So there's a couple sort of fact-finding things that I think council would need to review before, committing to that type of response. Yeah.
Correct. Yeah, we're dealing with an HOA. It's been very challenging. It's been a back and forth between the attorney and the county on how they're trying to, we have people parking in the streets. It's been a challenge. So yeah, you definitely have to be working with your association attorney when it comes to that. Are there any questions there that pop up to you, Andrew? I think we've pretty much, I know we have a series of them.
I think we've done.
I think we've gotten all the main ones.
Yeah. And the ones, listen, we would love to get to every single question.
Right.
Some of them are very document specific. So again, we really would not know unless we've reviewed exactly what your documents say. So we really appreciate, everything that you guys are, asking. I'm just zooming through to make sure there's not sort of a general.
Sure. Well, while you do that, I'll let everyone know. We've had several questions with regards to the presentation, as well as the video itself. With regards to the presentation, I'll let Jeffrey know at KBR to email it. I do believe that they were going to share that with all those that were present today. Also, we will be posting it on our YouTube channel. If you haven't subscribed to our YouTube channel, I kindly ask that you subscribe. We will post it within 24 hours. We also have the other webinars that we've done with both Andrew, as well as Mike, as well as Lisa, on our YouTube channel. So you could share those videos. It'll give the full length of the webinar. And also you'll see my pretty face once a week on Tuesdays when we have videos coming out.
That's cool. That's cool.
So I guess for any closing remarks, Andrew, is there anything that you want to close off with? I do know you gave a lot of homework. Everyone's going to have their Thanksgiving full.
I know. I used to hate homework when I was young. So maybe this is some sort of subconscious thing. Definitely fill out the surveys, and we really read every single one. And we appreciate, I know I certainly do, any constructive feedback that you all have. So please, we really appreciate, certainly if you're a CAM, you're going to want to get your credit, but we really do read that. We're a law firm and we're attorneys, but at the end of the day, we're in the customer service world, right? And we don't forget that. And we want to make sure that the courses that we give, we want to make sure that our clients, whether they're current clients, potential clients, maybe future clients, we really do appreciate whatever feedback that you all have. But with that being said, I want to thank everyone again. Raphael, thank you so much. Always a fun time, and hope to see everyone either in person or on Zoom again soon.
Thank you. Thank you so much, Andrew. I know for those that have asked again how to be able to view the webinar, please pull out your phone. You can scan over here and it'll give you a direct link to our YouTube page. Make sure to subscribe. I do want to thank you all for being here today. I wanted to thank, more importantly, Andrew and Jeffrey, and also congratulate Jeffrey. I do know he's about to get married from your team.
Yeah.
So thank you all for being here. We're very appreciative of KBR of allowing us to host this webinar with them. I know every time we do a webinar together, we have a ton of questions, and it's always great to be interactive with both our board members as well as our managers. On behalf of Affinity Management Services, we're grateful for all of you. Again, to those board members that do what you do for not being paid, thank you for being a leader in our community and for taking the time to gain some additional knowledge on how to do the best job possible for your membership. And to those managers, thank you for being the leaders within our communities as well and guiding our board members and really taking the time to gain additional knowledge to do a better job for our industry. It really makes our industry much stronger and much better as a whole. So thank you all. I look forward to seeing you at our next webinar. Everyone have a great day.
Thank you all. See ya.
Bye-bye.
Bye.